Hello and welcome. My name's Wes Ward from Govern With. This is the final episode in our cyber series. For those who don't know, we had a very exclusive Chatham House Rules Insight session not that long ago with Jonathan Green and Vera Visevic from Mills Oakley to answer the question, can directors be held personally liable for a cyber attack? The feedback was outstanding. It was very strong. People really appreciated it. And we decided to put on an encore webinar. So here we are today. I thank everyone for engaging. I thank everyone for the participation. We're going to move on. It's a really exciting time. But one thing that we did find out when we did our last two webinars is not many people really knew what Govern With does and knew nothing about our flagship product called Boardroom Plus. So for the next 30 seconds, I'm going to explain what we do. We are Australia's leading platform for governance review. That means a whole of board governance reviews, director skills matrix reviews. With those assessments complete, we instantly create director development plans. They're instantaneously. So technically, you're only 90 minutes away from a 12-month governance strategy to implement against your biggest capability gaps. But most importantly, there's board succession management tools inside the platform. And as a result, there's 71 risks that we consider in our platform for boards like you on today across 3 different categories. Those categories are the traditional professional skills, but we also include contemporary skills like cyber, the one we've been talking about today, and the one we'll be talking about in 2 weeks' time when it comes to ESG. But also, depending on your sector, we have governance assessment questions to identify the risks specific to your not-for-profit sector. So without further ado, I'll tell you a little bit more about our journey, the governance data and our impact. Govern With has been in action for over 10 years. We have contributions from over 6,000 directors into our data sets, and that's reviews from over 600 boards. And the impact we're having amongst our clients and our communities, revenues of over 10 billion, employee bases of well over 50,000, and volunteers, because they're critical to the communities that we serve, over 30,000 on that journey. The not-for-profit sectors that we serve are health, human services, the aged care sector, education, independent schools, and of course, communities. That's what we do and what we do best. And our partners are Aon Insurance, one of the leading insurers globally, the Victorian Healthcare Association, the Governance Institute of Australia, an incredible education resource, the ACPA, the leading aged care industry body, Women on Boards, and Convene, the leading board administration portal for the not-for-profit sector. Here's a quick snapshot. I can't go through them all and we need to get on, but here's a little snapshot of some of our clients. As you'll see, we are very strong in the highly regulated not-for-profit space. But today you're here to learn about, if you're a director, can you be held personally liable for a cyber attack? And of course, we've got the experts from Mills Oakley lawyers back in again. So first of all, I'd like to introduce the first of our panelists today is Vera Visevic from Mills Oakley. Vera, welcome to the show, and just briefly tell the audience about yourself.
Thank you, Wes. I'm a partner at Mills Oakley Lawyers and been practicing now for about 30 years, most of that in the not-for-profit and charity sector in Australia. Fantastic area of law to work in, very fulfilling, very diverse, and definitely keeps me on my toes. I see all sorts of different situations, and to this day, I'm still surprised by some of them, so I'm never bored. The firm has a team which specialises in this area of law, and I'm one of the partners in it, and you can see on the screen there that I sit on a number of boards myself just to get that practical experience of what it means to be a director and to understand, I guess, from an internal perspective, how charities and not-for-profits work. And to my right here is Jonathan, who is a member of my team, and I'll let you introduce yourself.
Yeah, thank you. I have a background working in the not-for-profit and charity sector, running charities and establishing charities, and sitting on a number of charity boards as well. And then work in Vera's team, working across a range of different areas. You know, every day, as Vera said, is different, and we provide services and support to charities across a huge range of different areas, whether it be workplace relations issues or commercial agreements or trust, tax, a whole range of different things, mergers and acquisitions. So it keeps it interesting, and it's great to be working in a space where we know that, you know, that the work has an impact.
Absolutely. And being both of you, but having multiple board positions really shows that amount of experience and commitment to the not-for-profit sector as well. So welcome to the show. Thank you so much for coming along. And of course, it wouldn't be a Govern With webinar if we didn't have the governance guru herself, the CEO and founder of Govern With, Fi. Thank you for coming along and spending a bit of time with us today. Tell us quickly just your journey about how we've got here today.
Thanks, Wes. Hello, everybody. I developed my passion for governance when I was a really young CEO of a hospital in the rural area. And I experienced firsthand really good people, including myself, doing governance really badly. So I've been on a mission ever since to assist with what is it we need to help us do governance better. Originally, I was a consultant after that. And then in the last 10 years, I've been understanding how to bring technology in to enable access to what we need to be the best we can. So that's what I've been doing with Govern With. And today really is based on some of the extraordinary data that we get to highlight what are our board's top risks right now. So thank you, Wes. And thank you so much to Mills Oakley.
Wonderful. Well, before we really crack in, let's do a poll question. I really like doing these polls, and it really tests the temperature of the audience right now. The question is today, did your 2023 governance review of both the board and your director skills matrix identify any capability gaps in relation to cyber risks? Okay, so when we talk about some of the issues you might be thinking about, is it helping you give you the board or the directors the ability to ask informed questions, the tools assignment, the resources to execute. And of course, we'll be talking about the tools. We will reveal the results towards the end of the show because we've got some amazing content to get on with. Now, Fi, it's really important. We've been through 3 months of cyber training, essentially, 3 webinars plus this very acute webinar in terms of liability. But it does remind me of a time, and we've discussed this previously, that is cyber now the zero moment in clinical risk back in 2016-17. And for those who don't know, it would be helpful with just a little bit of background, Fi, about what the issue was at the time and how it relates to today.
The issue back in 2017 was that we had boards of hospitals who didn't actually have an understanding of health or clinical governance in particular. And in one particular board, they did not know, therefore, the questions to ask. And on their watch, they didn't notice or inquire about a trend of stillbirths with babies that was happening. That led to a complete upheaval of the whole system, in that directors in the future on health boards needed to understand the sector they were in. They needed to understand clinical governance. And what that meant was that directors really needed to take seriously, this is incredibly serious, that you actually need to understand what the top risks are of the boards that you sit on. There needs to be reviews that understand the skills of the directors. And as a consequence, a plan needs to be in place if the directors don't have those skills, but bring other skills to bring them up to scratch with what the top risks are. So if you translate that, what does that mean right now? Cyber security, lack of knowledge about that in directors is a massive issue because you don't know the right questions to ask, like back in 2017, not knowing the right question to ask about clinical governance risks.
Right. Well, we've seen numerous examples, Fi, of not taking cyber seriously. I think the engagement we're seeing so far on this journey is proof that people are taking it seriously. And having a sneak peek at some of these results, the poll results, it looks like it is starting to come on the radar for the board. So that's fantastic. But basically what you're saying right now is that terrible moment back in 2016, 17, it's looking very familiar today in cyber.
Yes.
Thanks for that. All right, well, we shall move on. Last month, we conducted a poll. Do you have an incident response plan? These were the results. If you weren't aware, 45% said yes, they did. So it means they were prepared, but alarmingly, 55% said they didn't. And this was one of the reasons why we're having today's webinar, because we do provide incident response plans and a lot of other resources today. But it brought us to the conclusion that we really have to ask this question. So as a director, what does it mean to you? If the organisation and a board you are sitting on does not have an incident response plan, hasn't started having conversations about cyber risk at the boardroom table, and or hasn't taken any steps to mitigate cyber risks, then experiences a catastrophic attack that cannot be recovered from. And I mean, lights out, close the gates, we're all done, we don't exist. The question is, as a director, are you personally liable for that failure? And that is the reason why we have Mills Oakley on today to help us answer that and many other questions. So what we'll do, Vera, I know there's a lot of grey areas in law always, and this question is no different to those grey, but let's talk about some of those grey areas because I know you've got some strong opinions on it, which will be very helpful for the audience. And then I'll ask you also about the grey areas. Fi.
Thank you, Wes. So the not-for-profit world has obviously benefited a lot from advances in technology in recent years, as has the business world and other sectors of the community. But from a legal perspective, with every new opportunity comes a new responsibility. And there has been a lot written about this, especially in recent times, as to whether the existing directors' duties that apply to directors of every organisation, including not-for-profits and charities, have those duties expanded to include ICT, which is information and communication technology. And a lot has been written in recent times to the effect that it has expanded. You would all know there are 5 or 6 main directors' duties that exist: to act in the best interests of the organisation, to not trade whilst insolvent, to exercise care, skill and diligence, manage conflicts of interest, etc. It's the duty of care and diligence which is expanding now to include cybersecurity. And as with any director's duty, if it is found that a director has actually breached that duty, that's where that person could be exposed to personal liability. So AICD, which is Australian Institute of Company Directors, has been considering this for a while. And some years ago, back in 2016, actually wrote an article to the effect that cyber resilience must now be a part of an organisation's culture, and more importantly, that this duty of care and diligence that applies to directors does now extend to cybersecurity. This has been reinforced by a case that went to the federal court last year. It's the first case in Australia that's dealt with cybersecurity, and the case was actually brought by ASIC. So this is a sign that ASIC is no longer just taking on an educational role about cybersecurity, but is actually now starting to enforce what they expect directors to do about cybersecurity. So in this particular case, it wasn't, interestingly enough, ASIC saying that directors had breached a personal director's duty. It was more about the breach of an AFSL license. But it's interesting because, as I said, for the first time ever, they're enforcing what they believe to be an important aspect of running a business. And secondly, because the court actually did find in this particular case that the company had failed to have adequate cybersecurity and cyber resilience risk management in place. And the commentary on this case has said that it won't be long before we actually see cases going to the courts where directors are being sued for breaching their duties because they did not take cybersecurity seriously enough. In this case, as I said, the company was found to be responsible. and had failed to do what it should have done, the cybersecurity, and was forced to pay $750,000 towards ASIC's legal fees. Right, so this is just legal fees, $750,000. And the judge in that case said, and this is interesting, cybersecurity risk forms a significant risk connected with the conduct of the business. It is not possible to reduce cybersecurity risk to zero. We all know that, but it is possible, he says, to materially reduce cybersecurity risk through adequate cybersecurity documentation and controls to an acceptable level, which I'll get to in a second. So this case from last year has given us 3 lessons. Number 1, cyber risk assessments should be conducted regularly. It's not something that you do once and then you forget about. Secondly, that each organisation needs to have an appropriate response in place to any cyber event that occurs. And thirdly, if it ends up in court, the court will actually look to its own cyber experts to determine what should have been done by that organisation in that situation. So what we're looking at is this duty of care, skill and diligence. And the AICD Director's Guide has said, just because a director does not have specialist knowledge about ICT and cybersecurity does not mean that their standard is reduced, nor that they are excused from ensuring that there is appropriate governance over ICT and cybersecurity. So gone are the days where as directors we can say that is not my area of expertise. I'm happy if I know how to turn on the light in a room. I have no knowledge about IT at all. And so therefore, you can't hold me responsible. The courts are going to soon be hearing cases about this. And I won't be surprised if they say ignorance is not an excuse. You can have access to experts and you should have done what you could have done to protect your organisation. So courts are not unreasonable. They know that you're a not-for-profit or a charity. They know that your resources are limited. However, they'll still look at what you could have done within your limited resources to make sure that you had adequate protections in place. What I think is going to happen now is that when boards draw up skills matrices or matrices for future directors, they're no longer going to be looking for lawyers and accountants in the usual kind of skill. They're going to be looking at trying to find individuals who can join the board who actually do have some ICT experience who can help the board make sure that the board is doing the right thing in protecting itself. A few years ago, the federal government was getting concerned about cyber attacks and wanted to crack down on it by introducing some new standards that apply to businesses in Australia. And AICD said, look, you don't need to do that. We've got directors' duties. We think they're adequate to make sure directors do the right thing. However, some recent stats from June last year show that at least in the not-for-profit sector, I think we are way behind where we need to be in taking this seriously. So just to throw some stats out to you, this survey from last year found 42% of not-for-profit directors say they have a formal cyber framework in place, only 42%. And of all the sectors, so business sector, government sector, and the not-for-profit sector, the not-for-profit sector had the lowest percentage of directors who had a formal framework in place. And 20% of not-for-profit directors said they had no framework or strategy for cybersecurity. So that's 1 in 5 not-for-profits and charities that haven't done anything. Only 60% of directors from the not-for-profit sector said that they had an adequate understanding of the potential impact of a cybersecurity incident. So that, again, is a fairly low percentage. More than 50% of not-for-profit directors have had no cyber training at all. So the majority of directors have not had any training, which I think is also alarming. And only 66% of all not-for-profit directors in Australia saw cybersecurity as a high priority for their board. And again, this is the lowest across all sectors. So these stats, as recently as from June last year, show that we have a long way to go and we need to start cracking down on this, because whilst we're lagging behind, the law is moving forward. And as I said, it won't be long before we see cases where directors are sued for breaching directors' duties, and that could lead to personal liability. So where do we go from here? Number 1, you need to make sure that directors have some understanding of cybersecurity. They need to have that training. Secondly, start thinking about where you can tap into that expertise. You can have, if you can find someone, a director to join your board who's got that sort of background. If you can't do that, put together a subcommittee responsible for cybersecurity and bring experts onto that. Or if push comes to shove within your budget, pay for some external expert to give you that advice. But it's got to come from somewhere. And the onus is on us to make sure that happens. And the law is moving forward and we need to keep up with it. So on that note, Wes, I'll hand it over to you. Progress with this.
That's incredible insight. If anyone hasn't taken on board what you've just heard right now, there's alarming stats. We know leading up to today that the participation and acknowledgement of cyber is historically low in our not-for-profit sector. If that's not a wake-up call, I don't know what is. I was briefly going to ask Vera, you said that the courts will be looking towards a cyber expert. Do you think that's an incredibly high bar, pitting a not-for-profit director who's got little knowledge of ICT against that standard that the court's going to potentially appoint being a cyber expert?
Not if you think about that last point I just made, which is that if the board doesn't have the expertise amongst the directors, it's got to look to an external person. So you've either got to find someone on the board, on a committee, or someone external, some sort of consultant who's going to give you that objective advice about what is appropriate for your organisation. And that's what the court's going to be looking at and asking its own expert to comment on.
Fantastic. And later on, we do have some various governance models around cyber, depending on your resources and your budgets. So we really want to make sure that everyone's fully armed in this space to be able to attack the issue and acknowledge the risks and get on with it. But also, Fi, we talk about duty of care, but from a governance point of view, isn't there, the concept of acting in good faith going to apply just from a governance point of view, not a legal point of view?
Look, acting in good faith is incredibly pertinent to this. And to Vera's point about the ASIC governance principles, they also refer to the fact that boards do need to review and develop themselves, and they also need to review the individual director's skills. And they even comment that recruitment is not necessarily a solution to the skills gap, that they actually do need to be seen to be building their development. So, Wes, to your point about acting in good faith means that you actually do these things. Firstly, you do have to check from a governance perspective, do we have policies in place? Do we have training within our organisation? Are we addressing the culture around doing the right thing from a cyber security perspective? And secondly, it needs to be actually done that we check our directors' skills and that we educate them or develop their knowledge so that they understand the right questions to ask about how are those things that we have in place in the organisation for mitigating or managing cybersecurity going. As in, we talked about earlier with targeting zero. If the directors don't know the right questions to ask, it doesn't necessarily drive activity to manage that risk. And acting in good faith, how that applies to this is if you do the things that I've just mentioned and that Vera's mentioned, and you are still capable, it's still highly likely that you could have a cyber attack. At least you have done all those things and you acted in good faith. It may not have prevented the outcome, but you have got the right things in place. And I think it would mean that you could start addressing the attack that you are under a lot more quickly.
Absolutely. And thank you for that, David. Ruddock also spoke about in our last webinar about the low-hanging fruit, all those little things that don't require huge technical capability to implement, but you're sending that message that you are acting in good faith, that you are taking the issue seriously, and you're being a responsible director by doing those steps. And we'll talk about those models shortly. Thank you for that. Well, that was the grey areas. If we talk about the not grey areas, there's some things that we do know. And Jonathan, I'd like to bring you into the conversation now, because if we talk about the Privacy Act. That's not great in comparison to what we have been speaking about. Let's touch on that now and how that applies.
Yeah, thanks, Wes. One of the principal ways that cyber attacks occur is the attack of information that is stored in cloud-based systems or online. And information in Australia is principally regulated through the Privacy Act. Not all organisations are covered by the Privacy Act. If your organisation has a turnover that's less than 3 million, then you're not covered. However, there are some exceptions to that. And so there are quite a number of organisations that have turnover of less than 3 million that are going to come under the requirements of the Privacy Act. They're organisations that provide contracts or services, contracted or provide services in relation to Commonwealth government and often state government, often funding agreements will opt organisations into the requirements of the Privacy Act. Organisations that provide health services and hold health information, anyone who's disclosing personal information about another individual for benefit, for service, or for advantage, and when an organisation is dealing with an individual's tax file number. So there's quite an extensive list of organisations that might come under that 3 million turnover threshold, but still be required to comply with the requirements of the Privacy Act. And so my encouragement is that if you have looked at this and thought, we're not under those requirements, we're okay, to have another look and just to make sure that you don't come under those requirements. And even if you do, I think it's important to consider whether or not you might want to opt in. And there's plenty of organisations that do opt in. There's an opportunity for opting in. The register of organisations is viewable by the public, and so it can be good for your corporate governance and for your image as a not-for-profit or a charity to give people confidence that you're handling their information in a way that complies with the requirements of the Privacy Act. Principally, there's two key areas: personal information and sensitive information, but also health information flows out from those as well that the Privacy Act deals with. And your personal information is the general information that identifies an individual, their name and date of birth and those sorts of things. Your sensitive information is information that has that more sensitive nature to it, i.e., sexuality or religion of an individual. And those have to be dealt with and handled in different ways. And so it's important to understand and also health information, how those different types of information should be handled and what the requirements are if you do come under the Privacy Act each state will have a health information or health act that requires health information to be handled in a particular way. If you do come under the requirements of the Privacy Act and there is a breach that occurs, or if you have reasonable suspicion that a breach has occurred, then you're required to conduct an assessment in relation to that breach. And so that often is what will happen when there is some sort of data breach that's connected with a cyber attack, is information in relation to individuals that were held by an organization is released in some way or is taken or is put in a vulnerable position. And in that sort of instance, it's really important that you conduct the assessment and work out what has happened. You need to make sure that you're taking the necessary steps to ensure that serious harm doesn't occur in relation to individuals. It may be that serious harm does occur, and if you find that the breach has created a situation where there's individuals who may be at risk of that harm or harm may have been caused, then you need to take the necessary steps. And there's a time frame that you need to do that within. It's a short time frame, generally 30 days. And you need to, in that time, prepare certain information, release a statement, and make sure that those individuals who are affected are notified and have the necessary information regarding the breach that's occurred and what information might have been released. So for organizations such as yours that are working, on the ground, bringing in lots of information, often because you're working with different people, and sometimes it might be quite vulnerable people. It might be people who, there's a lot of health records in relation to. It is really important that you're on top of this and that you understand this and that you have a plan in place if these sorts of incidents occur so that you can respond effectively. Often it's actually the way that you respond. I think, as Fi said before, you can do all the right things, but you may still be victim of one of these sorts of cyber attacks. And it's the way that you respond to it that is actually the most important thing.
And I think also to that point, thank you for that, Jonathan, is that we do provide those resources at the end of this show. We're emailing them out. We're talking about incident response plans, the checklist, the things that you can put in place because you're required by law to do these things. Now, you've heard it from the cyber experts. Now you've heard it from the legal experts. So I'm not sure we can, reiterate this message any stronger than we have. It's really helpful. And it's also worth knowing that we know that health data and student data are the top 3 targets for cyber attacks. There's finance data, but health clinical data is the most prized, valuable data on the dark web. We've found that out from the experts. And so anyone who's in those sectors need to be hyper vigilant about how they go about it. Now, Jonathan, I want to switch gears slightly to some case studies and research in these areas. You've been at the forefront, you've seen a lot, but you've got some ideas around what's happening and some case studies.
Yeah, so particularly coming out of the pandemic and the time that forced a lot of organizations, as Vera talked about before, to go online and to have much more of a cloud-based presence. Charities and not-for-profits are very vulnerable, often because they've, may not have as much of the resources as some other organizations. They may have information, as Wes said, that is particularly of interest to those who are undertaking cyber attacks. And so this is a space where there is perhaps lack of resources sometimes, but lots of opportunity for those who are undertaking cyber attacks. In 2021, a number of organizations involved in technology in the charity and not-for-profit sector, a survey of 600 not-for-profit organizations, and they found in that survey that 44% of those not-for-profits did not have an information security incident response plan, and 69% of them had moved or were in the process of moving to the cloud. And that was an increase from 58% in 2020, meaning that really there's a lot more of these, community-based and not-for-profit organizations that have information and significant information that is out there and accessible. And I'm sure for each of your organizations, as you think through, the various databases and where information is kept, you could probably identify some information that may be kept in the cloud or may be accessible. Even information that might be kept on a personal device might then be available through the cloud. So most organizations would have some vulnerability to this. So it's certainly something that a lot of organizations are unprepared for, but it also, is something that many are vulnerable to. The cost of cyber attacks is significant. Here in Australia, the cost is around 29 billion to Australian businesses, and it's about 7 trillion globally. So it's massive, it's significant, and that's, big picture, cost-wise, but the cost upon individuals as well if their information is released. And I've heard many stories of individuals who they are caught up in these sorts of attacks and, it takes years and years for them to sort it out and can have a significant impact upon them personally as well. So that cost is not insignificant. There's certainly a number of not-for-profits who I think sometimes it can be easy to think that, it's just the big players or the big companies that are at risk of this, the banks or the Medibanks or Optuses who all have had, notable data breaches of recent, but certainly that's not the case. And many not-for-profits have also had these sorts of incidents as well. The difference perhaps has been that, some of the more notable not-for-profits who have had these incidents have responded well and have had, appropriate steps in place to ensure that the breach is contained. So one example is the Australian Red Cross Blood Service, who inadvertently saved a list of 550,000 prospective blood donors to a publicly available portion of a web server. Fortunately, the person who found that wasn't within the Red Cross, but was an honest person who reported that to the Red Cross, and they were able to deal with it. They put their data breach plan into place. They did an investigation. They contained the information, and the story ended well. Another example is Anglicare in 2020. It was held to ransom over a very large amount of sensitive information that was stolen from its data system, its cloud system, and the data, involved quite a significant amount of personal information of individuals. Anglicare refused to pay the ransom. They reported the incident to the Office of the Australian Information Commissioner, activated their data plan, and they were able to contain the situation and minimise the impact and the harm that was caused. They worked closely with the Australian Cybersecurity Centre and the New South Wales Police Force. That's not to say that there was no impact on that one, but they certainly had a plan, they put it into place, and the situation was able to be contained. Another example is Oxfam. In 2021, they were victim to a cyber attack, and attackers accessed the database containing names, phone numbers, and even bank accounts of some of their supporters. Once again, they contacted the Australian Information Commissioner and the Australian Cybersecurity. They activated their plan, they notified individuals, and they took steps to protect their information. And once again, that's part of why we didn't see this one as a big news story like some of the other big corporates that we have seen. So as you can see, these are well-known charities and organizations that have a significant reputation. They took necessary steps. Although they, were well prepared, they were targeted, and these situations were able to be resolved by being prepared and being able to activate that plan when needed.
Thank you for that, Jonathan. Now, going back to our original question, Vera, around taking no action. And I'll go back to that slide just to remind the audience, this one here. If there's no incident response plan, there hasn't been any conversations or activity, and there hasn't been any steps to mitigate cyber risk, and the attack happens, are you responsible? I want to introduce this idea of foreseeable risk and your opinion on this. You've touched on it previously, but let's just talk about, in this scenario, do you think the directors are in a lot of trouble?
I think they would be. The law it tries to be understanding of how difficult it is to run a business or a not-for-profit or a charity. And if something unforeseen happens, for example, the pandemic, and organisations weren't prepared, the law understands no one saw that coming. And so therefore, it would have been unreasonable to expect directors to have been prepared for it. But as we observe what's going on around us, and we see that, you'd have to have your head in the sand to not realise that there are many cybersecurity events happening around us. It's in the news all the time. Similarly, with even climate change, we're seeing across Australia increasing incidents of flooding, bushfires, and the like. The law says if a reasonable person could see that this is becoming a more regular event and therefore a foreseeable risk, it is the responsibility of directors to talk about it, to assess how that foreseeable risk could affect their organisation, and to then be responsible enough to do what they can to protect their organisation from that risk. So with all of the different stories that Jonathan has shared with us, I don't think there's any way that a director could say, I never expected that could happen to us. It is highly probable these days And directors have to take this seriously, have the discussions, make the decisions, and put in place frameworks to protect their organisation. Otherwise, yes, I think it's highly likely they could be held personally responsible.
Thank you for that very clear warning to everyone out there. You did touch on foreseeable in the climate realm. We will be having a climate webinar coming up in a week's time, so we'll let people know about that. But I think this point of a reasonable person acknowledging that there's a regular event or a regular pattern happening is the catalyst that it should have been foreseen. Have I interpreted that correctly?
Yes, you're correct. Yeah, you're right.
Okay, well, for a reasonable director who's seen all our webinars over the last 3 months, I think they'll be fully informed that this is a foreseeable risk. Michael Parent from Aon said, you will be attacked. The question is how many times and how much each attack will cost the organisation. So it's not a matter of if, it's when. It is foreseeable, and you've just been advised by Mills Oakley that you could be on the hook because this is extremely foreseeable. But it's all well and good to talk about the problems and the issues, but let's talk about some solutions. And we've seen some already, and we want to make sure that we're part of that solution. And that's why Mills Oakley is on this call. That's why we've spoken with Aon. That's why we've spoken with Solar Security as well. And Fi, we also spoke in previous webinars. You know, a lot of the people on the call today, their organizations are under-resourced. It's not easy, you know, you're out in the region, so even the human capital around this expertise is limited. Let's quickly talk, and I'll give you 2 minutes to talk about the three, you know, these particular models that we could employ. I know you've seen it in other areas of risk. Let's talk about how people can do something for their board and their organisation and their community.
A reasonable response from a board of directors as to what to do now that they understand that cybersecurity is a #1 risk is to consider, if you can't afford, as Vera suggested, to have your own committee that addresses this, to add it to the risk committee and bring on an expert to that committee to advise at that committee level, to then advise to the board. It needs to become a standing board agenda item. If something is a top risk, such as in hospitals, clinical governance, or the voice of the consumer, it needs to be an agendaed item so it isn't forgotten. And there needs to be, as Vera's mentioned, a dedicated cyber subcommittee if you're a large enough organisation to afford it. And last but not least, I'd like to recommend in regional and rural areas, or even in some suburban areas in cities, that you strongly consider a shared resource of a committee between other organisations. And the most important thing you need to recognise about cybersecurity is that it doesn't have to be with a same type of organisation. So, for example, at the moment in health, there are regional subcommittees for clinical governance, drawing on the skills of the larger organisations for the smaller organisations. But even more importantly, with cybersecurity, you can actually partner with any other kind of organisation, because cybersecurity is a risk everywhere. And so you could organise with other organisations to share that resource and meet locally.
Thank you, Fi. Of course, when we talk about resources, we've got two outstanding resources on this call today at Mills Oakley. Obviously, they're very adept at the cyber issues, but Vera, just briefly, it's not just cyber, you know, you supply services to all areas of law.
Correct. So we've got a team of about 30 people, and we'll look after all of the legal needs of charities and not-for-profits, from tax to incorporation to constitutions to governance to grants to funding to fundraising, you name it, we can help you.
Fantastic. And before we get to the poll results, it's also, we promised that we would provide resources. This will be in the email that we follow up with, including the slides and the webinar replay, but also Mills Oakley not-for-profit board cybersecurity checklist on top of a lot of incident response plans as well. So you have everything there to get into action, and we can provide the contact details of the team at Mills Oakley if you need them at all. All those resources are available. Now, obviously, we have resources as well. Boardroom Plus is that tool that you need to assess the capabilities and understand the risks against your strategic plan. And so we do board review, we do that directed development. So you can decide whether, if a risk is critical enough, whether you need to recruit for it or you develop for it. And that's why the board succession is really critical. And it was to Vera's point early that you need to start looking at recruiting this capability against that risk. And so when you're looking at your board composition, and all that data is quickly available once the last assessment is complete on the Boardroom Plus, you can start to look at your board composition and think about the periods moving forward outside of this 12-month cycle. Within your strategic cycle, who do you need to recruit? Who do you need to develop against your strategic plan and against this governance roadmap that we provide instantaneously once you've finished your assessment? So really consider thinking about that. But our poll results, Adrian, I've got you in the background. Let's share those results. I'm just having a quick look today, right now. Did your 2023 governance reviews, whole board and directors, identify gaps? And the data saying 77% it did. So it's working fee. This is really positive. There's still 23% that said no. So there's always room for improvement. We know that, but this is a foreseeable risk. So thank you for your insights there. Really important. What I'd like to do right now is just thank everyone who contributed to the cyber series, including Vera and Jonathan today. I thank you very much for your participation and really getting to that pointy issue of the legal risks associated with cyber. Obviously, Michael Parent from Aon, for yourself, and David Ruddick from Solus. That was really good. If you want to catch up on any of those webinars, they are on the governwith.com/webinars. Page. So that's really good to know. Those resources are always available, uploaded to YouTube, onto our blogs, and any ancillary resources as well. So if you need to have a demonstration to see the capabilities of Boardroom Plus, this is all you've got to do to book a time in with myself or anyone of the team. governwith.com demo.